One thing I was struck when I looked at the resumes of Tonya and Ginny was how much your list of firsts, lesbian is not the most striking aspect. It's much more gender, race. Am I projecting too far out here when I look at your resumes and make that observation? Or it's very much knitted up in the same ways that you were firsts. Do you have any observations on that?
I think that's fair. And my career spans, I became a lawyer in 1980, and I became Solicitor General in 1986. And that's all through the time period when it really was the L word. People did not say the word lesbian in polite company, or gay, for that matter. It was homosexual. And it was uncomfortable, and it was really a subterranean discussion and acknowledgement. At least, okay, that's in San Francisco less so than Oregon, okay? But certainly in Oregon and in the nation more broadly. I was out from the moment I was asked to be in management in the Attorney General's office. But being out was still kind of a quiet conversation, if you would, in the 80s and early 90s. So what was much more visible and going on was that I was a woman doing those things. And that's maybe in my own way of thinking too, as one of the women who went to law school in the late 70s and was looking for role models and not finding very many of them. That was much more of where I think my own mindset was in terms of what there was to be accomplished. Women still are trying to break down certain barriers. A lot of them have come down. But I was very much in the middle of the generation, interested in seeing which ones we could hurdle. So I think a lot of the first got identified in that way. It was then more at that point that, for me, the first time really being out as a lesbian was in the public discussion per se, was when I got appointed to the Court of Appeals in 1997. There were openly gay judges on the trial bench in Oregon at that point, at least a couple. And there were openly gay lawyers in the bar, but it was still a conversation that was just opening up. And I went to my investiture in 1997, and my partner who was here was my partner of 10 years at that point, and the question was, in my own mind, am I going to talk about Colleen in my investiture? Because people always talk about their families in their investitures, but nobody in any Oregon courtroom, even the openly gay judges, had ever talked about their partners in their investiture. So I kind of waited. Nobody knew, including me, if I was going to do that. So I waited to see what the atmosphere was in the investiture, and it was actually kind of raucous and fun. So it fit, and I talked about Colleen as my partner of 10 years, and that changed the conversation. Even the governor, who knew I was a lesbian when he appointed me to the position, he didn't know who my partner was. It happened that he also knew Colleen. So he was so excited to run up to me after the ceremony and say, "You, Colleen, I didn't know." So I think that's when the first as a lesbian began to be sort of part of what everybody was noting, was just because it was out in a different way at that point.
It brings to mind, those of you who've known me a long time have heard me tell this story, it brings to mind a lovely quote from Rita Mae Brown that one's sexuality in the abstract is really quite boring, but denying someone who you love, that is a sickness. Thoughts on the bridges you crossed?
Well, going back to your original question, which I think is related to what you just said about the resume and what you noticed, and it's an interesting observation, because when I was working with the person I work with to put my marketing materials or bio or whatever it is together, whether it's for campaign or for whatever reason, we always talk about this issue. And the thing that I think is important for you all to know, because it's going to be pervasive throughout this conversation, is that I'm a communications major. So my undergraduate degree is in communications and public address, and I have this professor who's always in the back of my head saying words don't mean, people mean. And that's important because whenever I have something put together, I'm always thinking about the fact that I may mean something by what I'm putting on this paper, but the person reading it, they will have a very different meaning of what is here, and I can't control whether they capture and appreciate what I'm intending to convey. All of that is to say that when I put my resume together, so I look at it and I think, one, I can't say I'm the first gay anything, because I don't know that, because I know that there are people who are not living an authentic life, and so there's no way that I could say I'm the first gay anything. So then I got, my next choice is to put that I'm the first openly gay something or another. Well, I've been told that I'm the first openly gay African-American elected official in the history of the state of Texas. I don't know that to be true. I don't know any way to go and figure that out, but what's, but what's really important to me about it is this word, again, we're back to the words, this out and open, and again, we're focusing on sexuality, and these words I don't think do justice to what it is I really want to convey. And what I really want to convey is I want something on my bio that would suggest to someone that I am a member of the gay community so that I'm accessible as a role model. That's really the only reason that it's important. Otherwise, it's not important. I know without a doubt that there are lawyers right now and law students mining and sifting, in the words of Toni Morrison, trying very desperately to achieve what God has graced me to achieve. I want to be accessible to them, to talk to them about my journey. So what I do is, well, I don't have anything on my bio that says I'm the first gay or the first openly or the first out. What I do have is information on there that would let someone know that I am a member of the community. So, for example, I serve as a commissioner on the American Bar Association Sexual Orientation and Gender Identity Committee. I'd like to change the name, I can't. And I'm a member of the committee, and so I put that on my resume, hoping that that would provide some insight to someone who's looking to access me as a role model, and certainly I want to be accessible in that way. So that's the way that I deal with it, because I definitely don't want to send the message that I celebrate these pieces of myself, but I'm ashamed of these other pieces, or I don't celebrate these other pieces, or I at least don't share them. And so that's the way that I found to try to balance it out.
So we've been kicking around here on what I think is a really interesting, and permit me, Vaughn, this one isn't for you, but it's just the world of elected politics, and elected politics, being a judge, and being a sexual outsider by some measure. And I don't have to come up in, it has to come up in the courtroom. Does it come up in political campaigns? Because you had a relatively tight primary your first time. You've sailed through since then.
I was in a three-way race. It was a big part of my thinking in terms of whether I would jump into that race. That was 2006. I'd been on the bench at that point for about 9 years. The fact that I was a lesbian was known and knowable. And once I went through my investiture, it finally was information that tended to precede me, as opposed to information that I had to find some way to convey if it seemed appropriate. So going into the election like that, it was part of a long conversation that Colleen and I had as I was being approached to run. Oregon already had my colleague and good friend, Justice Reeves Kistler, on the bench, who is an openly gay male. And
just, if I may interrupt, just to underscore that, that means 2 out of
2 out of 7.
2 out of 7.
And we have a third openly gay candidate running for the court right now as we speak. So Oregon's a little different than some of the other states, and our culture is a little different on these things. So there was a long conversation, many at home. Eventually, it just coincided that we were having an annual judicial conference with all the judges in the state, and I ended up being lobbied by a room full of about 30 women judges. I realized later it was kind of a setup. To run. And after a long discussion and discussions with others, I said to the group, because we hadn't talked about it. And I said, here's one of my concerns, among others. I don't know that Oregon's ready for 2 out of 7 openly gay judges on their state's highest court. Now, with the exception of a few people in the room, a few of the women, they were all trial judges. I got overruled instantly. I encouraged them to take my issue under advisement, and they declined. But they all said, no, it is not going to be an issue. And they really, really believed it. I thought, well, that's because they're them and I'm me, and I have to worry about it. And it was true. During the campaign, it just never came up. The information got out early. It really got out the second day after my press drop because of an interview I had with another reporter. And at that point, it was, nobody asked, nobody made an issue of it. It was just a campaign on credentials. And it was, it falls into the category of the things you worry the most about don't come to pass. It's the other things that come to pass. So it was, and I think it's been true in the current campaign with the current candidates. Orientation has not been an issue in that, so.
And you had an opponent, you mentioned to me earlier, who would have known how to have used it if they'd wanted to.
Yes.
A former real politician,
yes.
former gubernatorial candidate.
And I, both of 3 opponents in the primary, then it was a runoff. The individual that went into the runoff was a former Republican candidate for governor in Oregon with great statewide name familiarity and a name that has a lot of traction in Oregon generally, and a very savvy politician. He never used it. Could have, would have known how to, never did. He was totally above board. And I do want to say on his behalf, he had been the labor commissioner, and he really is very good on gay and lesbian issues. So if he had used it, it would have been purely for political advantage. He didn't. And when he was labor commissioner, Oregon wrote one of the amicus briefs in the Romer case. It was actually he and our governor who signed off on it so that we would, in some part, have somebody to bill for the brief, I suppose, as part of it.